March 5, 2016, the day the judge's gavel fell, remains a hinge in our story. It is the date that anchors the public record, the headline, the certified judgment. But that rap of wood did not start the harm, nor did it finish the work of repair. To tell what happened and what followed, I must begin earlier, at the small domestic rhythms that people notice only when those rhythms are That transfer appeared on its face, to be routine, a buyer's name, a notary, a date stamp. The recorded owner, my father, was listed as absent, away on deployment with the National Guard. He had been mobilized on June 1, 2013, leaving my mother and him to maintain the house from afar. We discovered the transfer 3 months later, in November 2013, when a neighbor called to say a stranger had shown up at the house, saying the property belonged to him and that he intended to renovate immediately. That stranger did not, in fact, own our Lakehouse. Between that recorded transfer and the moment we found out, mistakes and opportunism compounded. The title company had relied on an email and a photocopy of a notarized signature. A broker had accepted the documents at face value. The buyer, or the person who presented himself as buyer, claimed to be an agent acting on behalf of my father. We did not know then how quickly ordinary paperwork could be turned into leverage when a person named as absent had no one verifying their intent. The weeks that followed were a blur of phone calls and paperwork. On November 27, 2013, I drove to the county clerk's office with a copy of our deed and the recorded transfer and discovered, inked into the public ledger, that the transfer had indeed been recorded on August 18. The clerk was sympathetic and competent, but the remedy was not immediate. Title insurance, civil suit, and eventually criminal charges would be necessary. We began the slow work of untangling a recorded legal fiction from the reality of ownership. The legal case, formally filed by the county prosecutor on January 14, 2014, alleged fraud in the preparation and recording of documents. An arrest followed, a criminal indictment in March 2014, and a civil suit for restitution filed in April 2014. The criminal trial opened on February 2, 2016 and concluded with the judge's decision on March 5, 2016. The court found for the state and for our family. The criminal conviction and the civil judgment ordered restitution for the proceeds of the conveyance and for out-of-pocket harms occasioned by the attempted sale. Those dates are important because they provide a public frame for what otherwise might read as private misfortune. They mark not only the arc of a single case but also the moment when a small town's institutions were asked to confront a pattern of vulnerability, the way legal forms can be weaponized against people who are, by circumstance, absent from their ordinary domestic institutions. If you ask me what I remember first from that period, I will say the small, mundane things before the court reporter's notes or the police log. I remember neighbors showing up with a spare key and a casserole, the habit of calling before you stop by, the ritual of sitting together at the kitchen table with a stack of papers and a cup of tea and reading them out loud. Those customs are hardly newsworthy, and yet they are often the sturdiest defenses we have. They preempted some forms of harm long before any statute could be amended. The day the judge's gavel closed the public part of the story, it felt like a decisive punctuation. Yet my father's experience of that sound was different from mine. To me the gavel felt like a restoration of order. To him it resonated as the weight of consequence, the compression of years of decisions and oversight into one sharp percussive instance. At the moment the ruling was recorded, color drained from his face until it matched the courtroom paper. He folded inward slowly, the way a person who has been supporting himself on a thin scaffolding finally lets it slip. He did not collapse theatrically, he folded and someone caught him before he hit the floor. People asked afterward whether that subdued falling was the reckoning. It was part of it. But the real reckoning, I learned, was dispersed across kitchens and phone lines, in neighborly visits and in the repetitive, tedious work of paperwork. The court's decision mattered in literal ways. Criminal accountability for the conspirators meant that some of the money was returned, restitution calculated to cover what had been taken. The civil judgment, entered on April 19, 2016, obligated the defendants to repay the sale proceeds and compensatory damages. Those written orders enabled the title company to cancel the fraudulent transfer and the county clerk to correct the record. But these institutional fixes did not by themselves restore the ordinary textures of trust, conversation, apology, the mundane, repetitive acts that make a life livable again. What followed in the months and years after the verdict was a patchwork of legal remedies and domestic repairs. Some of the restitution paid for immediate, visible fixes: the roof shingles where rain had seeped through a stubborn patch, the finishing of a basement so the grandchildren would have a place to sleep after long summer days, electrical repairs that had been postponed. It paid for counseling for family members who needed help naming and processing trauma, and it funded my father's therapy, where he learned, in specifics and over time, where judgment had failed him. It purchased small, corrective comforts: a porch swing that caught the lake breeze, a lamp that threw better light over framed photos on the mantel. These purchases were not symbolic, they were instruments of repair. They made the house livable without constant vigilance. Beyond the financial remedies, the case precipitated institutional change. Title companies that did business in our region reviewed procedures and upgraded their verification software. Beginning in late 2016, one of the larger regional title firms introduced a mandatory multi-factor verification step for any transfer involving an absentee owner, a recorded phone number callback, and the requirement of documentation showing the owner's presence or specific, notarized authorization. In January 2017, the county clerk's office instituted a second, in-person signature requirement for transfers where the recorded owner was noted as absent. Local banks adopted routine callback procedures for wire transfers and high-value account changes, and some added a policy requiring joint account holders to be contacted on numbers on file if a transfer request was initiated. At the state level, the change took a longer arc. I had met, in 2015, a state legislator at a volunteer legal clinic I had been helping to organize at our county library. She listened to the facts of our case, to the precise way recorded absence had been exploited, and agreed to draft a narrow statutory amendment. The bill she introduced in January 2017 required express, documented consent from a recorded owner before a conveyance could be executed where that owner was officially marked as absent from military service. Legislators debated the measure in committee hearings in March and April 2017. It passed both houses in May and was signed into law on June 12, 2017. In legislative language, it was a small addition, a single paragraph to a property statute, but on the ground it mattered. It introduced formal friction that made it harder for unscrupulous people to exploit the ordinary rhythms of families that included absence for reasons of service. These reforms felt prophylactic and their comfort was real. They made certain future wrongs less likely. But they could not replace the years of care we had lost. Restitution could repair a roof and pay for therapy. It could not return time, nor undo the erosion of confidence that follows betrayal. My mother responded to the breach by turning her residual fear and anger into civic work. For years she had written the occasional column for the local paper. After 2014, those occasional pieces became a near monthly feature entitled Householding. Beginning in February 2015, she published a series of plain, exacting columns about the notary's role, the difference between durable and springing powers of attorney, why naming a successor trustee matters, and the importance of keeping beneficiary designations updated. She used dates and examples from our own experience. If you plan to be away for longer than 3 months, hand a copy of your deed to a trusted friend and notify your bank in writing, she wrote in an August 2015 column. Her tone was unadorned and practical. She offered scripts to use when calling a bank, step-by-step checks that were within reach of non-lawyers. Because she had learned from our scar, her writing carried authority. Readers responded. Letters arrived, some grateful because they had taken the checklists seriously and made changes. Others because they had been spurred to have a conversation they had long avoided. A woman from our parish called, in November 2016, to say she had reorganized her affairs and made a simple list for her children after reading a column. A young veteran wrote from a base in 2018 to say he had filed a durable power of attorney before deployment and that the simple act had eased his mind more than he had anticipated. What began as a single weekend of volunteer help at the county library in January 2015 became, by the end of that year, a recurring clinic. Volunteer lawyers, notaries, and social workers offered free consultations that grew quickly from quarterly to monthly. The County Bar Association provided pro bono hours. The Veterans Center partnered to reach service members and their families. A nearby high school civics class sent students to help with intake forms. Our first clinic followed a simple rhythm: Intake, a quick triage of needs, a brief meeting with an attorney or notary to complete 1 or 2 essential documents, and a clear follow-up plan. We distributed templates, a brief email a spouse could send to a bank to authorize a secondary contact, a script for calling a title company, a checklist of documents to scan and store securely, and we taught them in plain language. I became a regular at those clinics. I went not as a spectacle of misfortune but as a practical explainer. Over the course of 2015 and 2016, I showed people how to read a deed, suggested keeping scanned copies of important documents with a mutually trusted friend, and rehearsed until it sounded natural the phrase many families adopted, "Call me before you sign." We walked attendees through the differences between signatures done in front of a notary and those done via mail, explained how an improperly witnessed signature can leave an estate vulnerable, and emphasized the small but significant details. Who is named on an account, whether a power of attorney survives incapacity, whether the will on file is the latest version. The clinics made the technical seem ordinary and the ordinary seem technical enough to demand attention. We handed out laminated scripts that people could keep by the phone. If you receive a call about selling property, say, "I will call you back on a number I verify, please tell me where my number is listed." Students scanned and encrypted documents at no charge, and local veterans groups helped weave the clinics into pre-deployment briefings. There were limits to what advice could do. Human relationships carry their own logic of habit and avoidance. My father's collapse at the courthouse was a visceral reminder that wrongdoing is sometimes braided with genuine fallibility. In the years after the trial, he tried, in small consistent acts, to demonstrate a different way of living. He saved receipts. He ceased making unilateral decisions about joint finances. He fixed a neighbor's screen door, lent a hand with a lawnmower, and sent birthday cards with an exacting, careful hand. These gestures were not an eraser. They were evidence of a person attempting to live differently. At home, we ritualized attention to documents. Beginning in December 2014, and more formally after the trial, we instituted document night once a year. Papers came out on the dining room table: wills, powers of attorney, insurance policies, account statements. We checked beneficiary designations, verified contact information, and confirmed who would step in if one of us was away for an extended period. The grandchildren were included, bored enough to be children, old enough to learn terms like executor and trustee without feeling the full weight of mortality. We served lemonade and cookies while adults joked and grumbled through the work. The tone was light, but the effect deep. By ritualizing preparedness, we made it ordinary rather than exceptional. The lake remained, as it had always been, a mirror of sorts. I still go down to the water early in the morning. Sometimes alone, sometimes with a friend. On cold mornings I watch how a pebble's ring behaves, how ripples spread and then dissipate, how the surface keeps no ledger of petty indignities yet bears traces we can read if we pay attention. The house kept its own records of disruption: paint fussed over in a hurry after an acute worry, a shelf where family albums multiplied as if to prove memory could not be stolen. The lake's indifference became, paradoxically, a moral foil. It reminded us that the world does not wait for our sense of justice and that the only way forward is to keep attending to the ordinary, to the repetitive acts of care that sustain daily life. Outreach to service members deepened in 2016 and 2017. I spoke to battalions and spouses groups, not as someone with all the answers but as a person who could tell a simple truth plainly: yes, this can happen, here is how to make it less likely. We rehearsed contingency plans, naming multiple trusted contacts, keeping documents accessible while preserving security, and urging units to offer legal briefings before deployments that went beyond the basics of wills and powers of attorney. In June 2017, after the state statute change, a nearby unit integrated our one-page checklist into its pre-deployment packet. It was a small institutional adoption, but one that multiplied the reach of our practical advice. Soldiers and their families told us they appreciated the concreteness. They wanted to translate love into legal prudence. So we built tools: an accessible one-page pre-deployment checklist, issued first in September 2016, a short script a spouse could use when calling a bank: "Hello, my name is X, my partner Y is deploying. Is it possible to add me as an authorized contact in case of emergency?" And a brief template email to a title company to confirm how a deed would be transferred if needed. We explained, without legalese, what a notary public did and why a durable power of attorney differed from a springing one. We created mock dialogues for use in clinics. If you receive a call about selling your property, ask where they have your contact number listed. Say you'll call back on a number you verify. Those refrains were repeated until they were familiar. There were moments of ironic humility. At a community meeting in October 2016, a woman I had never met stood and described how, after reading my mother's column, she had called her brother to ask about their parents' papers. She discovered 2 wills naming different heirs. They resolved the discrepancy before anyone went to court. She thanked us for making such conversations permissible. Another man told me he had been too embarrassed to ask his mother about a deed. Our columns gave him the language to approach her with care instead of suspicion. These modest interventions felt like the true yield of civic life, not headlines, but changes in private habits that made exploitation more difficult. The state-level statutory amendment passed on June 12, 2017 did not solve every problem. It would not have unwound the particular sequence of missteps that touched my family, and it could not remove the ingrained vulnerabilities in people who were absent for reasons other than military service, illness or travel, for example. But it made that precise method of fraud harder to repeat. Other reforms, administrative and procedural, had broader teeth. Title companies instituted additional verification steps in 2016 to 2018. County clerks' offices instituted in-person checks for certain transfers starting in January 2017. Banks added routine callbacks for high-value transfers beginning in the summer of 2016. Professional associations circulated reminders to members to be suspicious of hurried requests to transfer property of an absentee owner and to insist on proof of intent from the owner. The money we regained paid for therapy and home repairs and small comforts. It also paid for patient domestic work that is harder to account for on a ledger. The time we spent learning to ask better questions at family meetings, the way we made a habit of checking documents while checking in on each other's well-being. We bought a porch swing in August 2016, hired help to catalog family photographs over the winter of 2016 to 2017, and contracted a local archivist in 2018 to scan and encrypt older family records. Those acts, mundane, domestic, were restorative. They were not substitutes for justice but the everyday measures that transform a house into a home again. My mother's columns broadened over time. After the 2016 to 2017 reforms, she wrote not only about powers of attorney and notaries but about storing copies of documents in multiple secure places, creating a prioritized folder of instructions that a trusted person could use in an emergency, and the practical difference between various kinds of proxies. She published a piece in January 2018 titled, "Make a Map of Your Papers," that gave step-by-step instructions for creating a binder and a secure cloud folder and for assigning a trusted second contact. Readers responded. A woman from our parish called in May 2018 to say she had finally organized her affairs and left a checklist with her children. A young veteran wrote in September 2019 that the clinics had helped him file a durable power of attorney before deployment and that the simple act had given him unexpected peace. The clinics matured and adapted. We kept the intake process quick and human. A volunteer asked what brought someone in that day. A notary or attorney listened and offered 1 or 2 specific, achievable steps. We avoided overwhelming people with a stack of legal forms and instead focused on priority items. Who is named on bank and retirement accounts, whether property deeds reflected actual ownership and not a decades-old mistake, and whether beneficiary designations had been updated after marriages, divorces, and births. We printed checklists in large type for older readers and handed out laminated scripts to keep next to the phone. Local students helped neighbors scan documents and save encrypted copies on USB drives. The Veterans Center ensured service members had access to basic legal orientations as part of pre-deployment briefings. By 2019, the clinics had a steady monthly schedule, and by 2020, in response to pandemic constraints, we shifted to a hybrid model of in-person intake and remote document review. Within the family, the work of repair was as much interior as exterior. I do not mean the legal paperwork, I mean the conversations about hurt and betrayal. My father worked to restore trust through ordinary acts. He saved receipts and showed them. He made transparency an actual practice. He began to share bank statements with another family member each month. He asked before borrowing money. He invited a trusted neighbor to be copied on certain transactions. Therapy, both individual and family, helped him understand patterns of avoidance, how convenience and an over-reliance on his own judgment had made him susceptible to flattery and pressure. Those therapy sessions did not erase what had happened. They taught concrete habits of accountability that mattered more than a single contrition. Document night became more ritualized and inclusive. By our 15th document night in December 2028, yes, the ritual endured. We had a printed checklist we reviewed annually: confirm beneficiaries on life insurance and retirement accounts, verify who is authorized on financial accounts, locate the most recent will, update durable powers of attorney and healthcare proxies, and record guardianship arrangements for grandchildren if necessary. We assigned someone to scan and encrypt a set of documents and to store a copy in a secure cloud folder accessible by a trusted secondary contact. We practiced awkward conversations, how to say to an aging parent, "We need to document your wishes," without sounding controlling, and rehearsed soft skills, listening, allowing silence, offering a joke to ease tension. The grandchildren, who once merely tolerated the proceedings, learned to recognize terms and appreciate why certain documents mattered. There were practical lessons, too. We kept a small folder of emergency information in an accessible place: the attorney's name and phone number, account numbers for key financial institutions, the location of safe deposit box keys, and names and policy numbers for insurers. We made sure someone not living in the home knew where those things were kept. If one of us traveled for an extended time, we now left a notarized letter authorizing another family member to act on limited, specified matters for the duration of the trip. These steps were not bold innovations. They were common-sense measures that only feel tedious until something goes wrong. There were private residues that did not yield to public remedies. My mother sometimes caught herself scanning the house for signs of a future misunderstanding. She replayed conversations and imagined different lines she might have taken. I woke on certain nights wishing I had talked differently with my father before particular decisions were made. Those stubborn residues of grief did not lend themselves to tidy closure. They required patience, a willingness to sit with discomfort and not smooth it away. Over years, the edges softened. The memory of my father's slow collapse remained painful, but it became contextualized by later tenderness and by the ordinary acts we did together. The question of whether justice mattered is the right one to ask. In narrow legal terms, the courtroom's decision mattered. It produced deterrence, public record, and some restitution. It required accountability from the immediate perpetrators and allowed the title company to clear the clouded title. But the decision was only the beginning. The deeper, longer work was social and familial, embedded in habits and routines, teaching people how to care for one another's affairs, making preventive practices culturally normal, having hard conversations about powers and signatures without panic. Those social practices, when internalized, are what make communities resilient. Stories multiplied. A neighbor told how, after reading one of my mother's columns in March 2017, he added a household rule: anyone asking to sign or wire money would be referred to a named friend on a list first. That protocol prevented hasty scams. Another neighbor recounted finding 2 wills after asking a simple question at a family dinner. They resolved the discrepancy quietly with an attorney's help and avoided litigation. A man in town called in 2018 to say the clinics had given him the language to approach his elderly mother about changing a beneficiary designation she had forgotten. These domestic adjustments, absurdly small in isolation, accumulated. Administrative changes, while unglamorous, had real effect. Starting in January 2017, the county clerk introduced a brief signature verification step for transfers involving absentee owners. Title companies added routine callbacks to numbers on file. Banks changed internal scripts so certain transfers required confirmation through a second channel. These are not sweeping reforms, they are bureaucratic adjustments. But they add friction to predatory schemes. They give families time to notice and act. My father's attempts to repair trust were intermittent. Old habits, making decisions alone, believing his own judgment sufficient, reappeared. The therapy he undertook helped him spot patterns of confirmation bias and avoidance. He learned to be transparent with finances, to ask before borrowing, to provide documentation for major expenditures. He asked to have another family member present at meetings involving significant decisions. These small, concrete practices of accountability mattered more than a solitary declaration of remorse. We accepted that some losses were irretrievable. Trust once broken is repaired imperfectly. There are still days when regret surfaces, when we revisit the past and find traces of what we might have done differently. Yet the accumulation of small practices, document night, clinic checklists, neighborly scripts, made recurrence less likely. It is modest comfort but real. There are other, quieter stories. An elderly couple spent 20 minutes at document night in March 2017 to update a will and in doing so, remembered to change beneficiary designations after a death. A woman discovered 2 incompatible wills simply because she had the nerve to ask. A young officer, Lieutenant A., reached out in May 2019 before deployment to ask for the clinic checklist. She wrote from a forward operating base that the list had made her feel steadier. These stories are domestic, lacking in drama, but they are the practical measure of civic response. Our town is not safe in any absolute sense. New threats arise as technology and finance evolve. But social infrastructure improved. More people learned how to call a clerk's office, where to put a notarized letter, how to keep a trusted friend apprised of critical document locations. Those practices do not eliminate harm, they reduce the odds. That reduction translates into real lives preserved from needless trouble. Looking back, I see the arc in 3 phases. Phase 1 is the injury, the recorded transfer of August 18, 2013, the discovery in November 2013, the formal filings in 2014. Phase 2 is the public reckoning, charges in 2014, trial in early 2016, judgment in March and April 2016. Phase 3 is the long repair, the wave of procedural and social changes 2016 to 2020, title company protocols, clerk's checks, bank callbacks, the state statute of June 12, 2017, and the grassroots civic responses, document nights, clinics, columns, routines. These phases are not discrete, they overlap and fold back on one another. The lake, patient as ever, provides a steady image for that arc. It takes in disturbance without judgment. Ripples spread and fade. The house, however, keeps a visible record, paint touched up in a hurry, albums that multiplied, a repaired fence. The lake's indifference became a moral foil. It reminded us that the world does not wait for our justice and that the only realistic response is sustained attention to the ordinary acts of maintenance. Institutional conversations followed. I spoke with military officers and civilian leaders about what a unit-level response should look like. We urged units to include short legal orientations before deployment that covered preventive measures. Ensuring a spouse knows where the deed is kept, creating a list of account numbers and trusted contacts, naming a durable power of attorney that survives incapacity. We recommended that family readiness groups keep a shelf of one-page checklists and encourage service members to bring a spouse or proxy to the orientation. The message was simple: love includes the painful, tedious work of documentation. Over time, the social meaning of absence shifted in our town. Before, absences due to service, illness, or travel were gaps to be endured. After, they became conditions shaping how we organized domestic life. We built redundancy into what mattered: 2 sets of keys, 2 people who know where critical documents are kept, a printed list in a secure envelope for emergencies. We taught children to ask the awkward questions before it was too late. Who is named on your accounts? Do you have a will? Where is the deed? These questions became a small kindness that preserves autonomy and prevents opportunism. At the clinics, we learned to respect limits. An hour is not a cure-all. We taught people how to triage, secure urgent documents first, make a simple notarized letter authorizing someone to act in an emergency, lock copies in a secure place, and tell a trusted person where they are. We advised against making big changes when emotions are raw and urged consultation before signing away critical rights. Our advice was sometimes repetitive and banal, but repetition is the secret of habituation. Hearing the same refrains enough times makes them part of ordinary living. Small local institutions changed too. By mid-2017, the county clerk's office had a signature verification step for transfers involving absentee owners. Title companies added callbacks, banks required second-channel confirmations. These adjustments are modest but cumulative. They add administrative friction that discourages predatory behavior. My father's therapy, begun in the winter of 2016, changed the way he approached decisions. He stopped treating financial decisions as private acts that did not implicate others. He began to invite scrutiny. He started to show monthly statements to my mother or me. He did not borrow against family assets without a written plan. He became more intentional about transparency. Those practices are not dramatic. They are persistent and concrete measures of accountability. Our family had to live with the knowledge that some wounds would not perfectly heal. But the rituals we adopted, document night, the clinics at the library, the columns, neighborly scripts, reduced the likelihood of repetition. They were practical, not theatrical. They did not erase the past. They made the past less likely to be repeated. In that, there was a modest justice, steady, unglamorous, lived in ordinary acts of neighborliness. When I walk the shore now, years after the judge's gavel and after the reforms took shape, I no longer hear that sound as an endpoint. I hear it as an invocation to continue repair. The gavel mattered because it created a record and enforced consequences. But what sustained us was the long work of living well enough that men's endure. The small civic rituals, legal clinics, document night, practical journalism, neighborly scripts, are the scaffolding that lets people go on without constant vigilance. They are not glamorous. They rarely make a segment on television. But they make ordinary living possible once a breach has occurred. If you ask what lesson to take from our story, I would offer practical instincts rather than platitudes. Prepare, name responsibilities, teach elders and those who will be absent how to secure their affairs, make care public rather than private. These are not formulas but habits, born in the scrape and slow mending of our lives. Law matters, its deterrent power and its remedies are essential. But law alone will not knit together what betrayal frays. The rest of the work, conversation, apology, repair, neighborliness, is social, often petty, and deeply human. I sometimes imagine a family, decades hence, sitting on the same porch as the grandchildren now do. Will they find fewer surprises? Will their rituals be different because of the habits we insisted on? I suspect they will. The pleasure in that thought is not triumph but relief. The sense that some of the cost we paid will prevent others from paying the same. That is a kind of justice in itself, incremental, unromantic, durable. It matters that certain dates mark the public story: August 18, 2013, when a fraudulent transfer was recorded, January 14, 2014, when the prosecutor filed charges, February 2 to March 5, 2016, the trial dates, April 19, 2016, the civil judgment, June 12, 2017, the effective date of the statutory amendment. Those dates give the arc of accountability. But what endures is less the verdict than the rituals that followed: document night, the clinics at the library, the columns my mother wrote, the quiet conversations at kitchen tables. Those rituals did not erase the past. They made it less likely that the past would be repeated. And in that, there is a quiet justice that moves steadily through the ordinary acts of neighborliness. The lake keeps its own counsel. It has watched us stumble and learn to recover in its peculiar, implacable way. Sometimes when I walk the shore I think again of the gavel. I no longer hear it as finality but as an invocation. Keep tending, keep checking, keep convening. The repair is not a line but a practice. It is the patient repetition of small civic acts until they harden into ordinary living. That is the legacy I hope endures. The legacy I hope endures was sharpened into a public image on April 19, 2016. That morning, in a county courtroom that had been packed since before the clerk's doors opened, the judge read the civil judgment that had been entered after weeks of testimony and cross-examination. The language was ordinary and technical: findings of fact, conclusions of law, directives about title and restitution. But the cumulative force of those sentences carried a human weight the judge could not soften. My father, who had sat stoically through most of the trial that ran from February 2 to March 5, 2016, looked smaller in that room than he had in the kitchen the morning after fishing trips. When the judge spoke of breach of trust and the taking of a home from its rightful owners, the words landed in a way that was both legal and moral. My father swayed. He did not speak, he did not cry out. He simply folded, a sudden, complete loss of balance that sent papers fluttering from his hands and drew a hush across the gallery. Court officers were at his side in an instant. Paramedics and an army of small, practical motions: blankets, the removal of the tie, a glass of water, restored him to a pale, trembling composure. News photographs later captured the arc of the movement: the judge's gavel, the rustle of papers, the slump of a man who had believed he could carry a family like a private asset. The image of my father collapsing became part of the public story because it crystallized the human consequences of what had been, until then, a series of documents and filings. The recorded transfer of August 18, 2013, the prosecutor's indictment of January 14, 2014, the months of legal maneuvering that followed, those facts were already on the record. The scene in the courtroom made people understand, in another register, how betrayal can look when it is suddenly visible. It did not garner sympathy for what my father had done, instead it forced a community to witness how ordinary choices can shatter ordinary lives. There were practical consequences to that morning as well. The presence of cameras and reporters yielded more public attention to the problem of absentee owner fraud. Editorial pages carried columns about elder protection and about how the law had lagged behind new methods of predation. Local television ran a short series, beginning the week after April 19, that interviewed clerks, title officers, and families who had been through similar ordeals. Those pieces were not sensational, they were procedural. They asked the question that had been so important to us: how could other families keep this from happening? One answer emerged rapidly: make the mundane visible. In the months that followed the judgment, clerks' offices reported an increase in visits by people requesting certified copies of deeds, asking about safe storage options, or wanting a notation on land records that an owner was to be contacted directly before any transfer could be completed. Title companies reported more stringent demand for secondary verification. Banks instituted mandatory second-channel confirmations for transfers coming from accounts linked to absentee owners. The statutory amendment that became effective on June 12, 2017, formalized some of these practices by imposing additional documentation requirements on transfers involving owners who were out of state, incapacitated, or otherwise unable to sign in person. The statute did not end all fraud. No single enactment ever could. It did, however, create friction, documentary, temporal, bureaucratic, that made predation harder and detection likelier. My father's collapse and the public conversation that followed also altered the tone of reconciliation within our own family. He had started therapy in the winter of 2016, a decision he said he made after recognizing how deeply his choices had wounded us. Therapy did not erase the bitter memory of having a home removed from under us. It gave him tools, narrative practice, accountability steps, a vocabulary for shame, that changed the texture of his apologies. He learned to speak in specifics, not merely "I'm sorry," but "I will sign this power of attorney form so you can see all outgoing transfers," or "I will let the bank speak to both of you before taking action on any property." These were small acts, but they converted words into checkable behaviors. There were further legal ripples. Our prosecutors, who had brought the case after the January 14, 2014 filing, used it as a model for training across the state. Prosecutors from neighboring counties traveled here in 2017 to observe how the clerk's signature verification steps and the title company callbacks had been implemented. Those trainings emphasized a crucial point: prevention is not merely an administrative convenience, it is a way to preserve autonomy. A brief from the prosecutor's office dated November 2017, part of the training materials circulated that year, outlined a set of red flags and recommended responses that later found their way into family readiness group briefings and VA caregiver workshops. On the ground, the civic response matured into durable institutions. Document Night, which began as an anxious community clinic in the winter after the trial, settled into a quarterly rhythm hosted at the library and at 2 churches. Each session followed a simple choreography. A lawyer gave 5 minutes of plain talk about wills, deeds, and powers of attorney. A notary certified signatures for those who could not afford private services. Volunteers labeled and sealed folders so families could know where documents were kept. A retired banker explained how to set up a 2-factor permission for transfers. Attendance doubled between 2016 and 2018. People came not because of spectacle, but because of obligation. Citizenship as a domestic chore. The anecdotal evidence of prevention accrued slowly but convincingly. In March 2017, an elderly couple spent 20 minutes at Document Night to update a will and thereby remembered to change beneficiary designations after a death. That simple act prevented a cascade of legal disputes. In May 2019, Lieutenant A, stationed abroad, wrote from a forward operating base to thank the clinic volunteers for a checklist they had posted online. She said the checklist had made it possible for her to sleep. These stories are not dramatic. They do not make headlines. They measure success by things that rarely attract cameras: an unwanted probate avoided, a bank double-checked, a will found when it mattered. The courts themselves adjusted their procedures in small ways that had meaningful effects. Judges began to insist that attorneys confirm whether parties to a real property dispute were truly present by asking whether anyone in the audience could independently verify an owner's capacity, as opposed to relying solely on documentary submissions. Court clerks implemented a practice of annotating dockets when an owner's capacity was in question, which made it easier to spot a pattern in subsequent filings. These legal adaptations were iterative and cautious. They respected due process while recognizing that the ordinary flow of filings can conceal predation. There were cultural shifts as well. For years, privacy had been treated as a sacrosanct virtue, especially in families. After the trial and the public judgment, many families reoriented privacy around mutual protection. The question at dinner tables shifted: what should remain private? To what should be shared so we can protect each other? Sharing did not mean prying, it meant redundancy and mutual visibility. 2 sets of keys became common. 2 copies of a deed, in separate secure locations, became a standard recommendation from document clinics. Lists of account numbers, kept in envelopes that were sealed but whose locations were known to 2 trusted people, proliferated. These practices, practiced and repeated, reduced the number of unilateral opportunities for wrongdoing. The town's practices had a ripple effect on nearby counties. In 2018, a regional conference of county clerks included a panel on absentee owner protections that referenced our town's experiences. County clerks from 3 neighboring jurisdictions adopted a callback requirement for transfers when the grantor's stated residence differed from the property's location. Banks instituted interbranch checks. Title insurers began to flag transfers involving multiple verifiable anomalies: an out-of-state notary plus an absence of direct contact with the owner, and then require additional proof. These were not legislative miracles but bureaucratic accretions, small resistances that, when multiplied, made certain kinds of fraud no longer worth the risk. Our family's internal economy continued to change in parallel. Document night became a family ritual we observed every January, a small annual audit that took no more than an hour but saved us from the slow erosion of memory. We built a living folder of receipts and correspondence that was photocopied and kept in a bank safe deposit box, the location of which was known to 3 family members. When large decisions approached, whether to sell, to take a reverse mortgage, to accept a caretaker, we invited a neutral family friend or a neighbor to the meeting as a witness. Those simple rules reduced the weight of confrontations and made the mechanics of decision-making clearer. There was, of course, resentment that lingered. Some neighbors continued to view my father with stark anger, others scaled their empathy toward him in small increments. Trust, once breached, responds unevenly to repair. My mother and I experienced days when anger flared and times when the practical benefits of the reforms we had championed felt like a poor consolation. I cannot pretend that justice was neat or complete. Legal remedies returned some papers, but not the years. The civil judgment of April 19, 2016, carried symbolic weight and some corrective measures, but it could not undo the emotional desolation of waking up to find your home gone from under you. Still, the measurable and the human effects of reform accumulate. By 2019 and into 2020, county clerks reported fewer successful transfers of property belonging to absent owners, and banks reported fewer suspicious authorizations slipping through their systems. These reductions mattered. They were not the end of exploitation. Scammers adapt and new tools arrive, but they meant more time, more notice, and more opportunities for intervention. As the years passed, the story seeded routines beyond government offices. Family readiness groups at military units circulated one-page checklists that echoed the document night advice. A parish in town instituted a Will Sunday once a year in which a lawyer gave a short sermon on stewardship and practicalities. The local high school included a unit on elder law basics in its consumer education class, teaching teenagers to ask their grandparents where important documents were kept. These are modest, almost humble changes. They are not the stuff of grand reform projects. But they are durable because they are ordinary. When I attend conferences now, panels with prosecutors, clerks, veteran service officers, I often emphasize the same point I learned painfully: law is necessary, but law is not sufficient. The statute of June 12, 2017, the clerk's verification step, the title company callbacks, these are structural improvements that lower the probability of predation. They create legal recourse and they impose friction. But the practices that make a community resilient are social and banal. Calling a bank, sealing a folder, teaching a child how to ask a grown-up where critical documents are kept. These are the acts that make the statutory protections meaningful. There is another, quieter legacy that has taken root in my own life. I find myself, sometimes without noticing, scanning for redundancy in my own household. I ask my spouse whether a document exists in two places. I ask whether our parents have named a durable power of attorney and whether that person is truly trusted. These are not dramatic conversations. They are the ordinary maintenance of a life lived with other people. They are the practices that, taken together, change the default from solitude to shared responsibility. My father's collapse in the courtroom will remain a vivid image in my memory. It is a moment that captures how law and life intersect in ways that are messy and painful. Yet the public and private responses that followed, training materials drafted by prosecutors, the statute effective June 12, 2017, document night, the county clerk's verification step, the note in the parochial bulletin, together created a less risky environment for people who might otherwise be prey. That is not to say the work is complete. Predators adapt, technologies change, the practice of neighborliness requires constant reinforcement. But the pattern of reform, legal, institutional, cultural, has made a measurable difference in how families approach absence and vulnerability. I do not imagine a time when justice will be everything I wanted or that the past will be reversed by ceremonies or new forms. What I see instead is a slow accretion of practices that make the quotidian less dangerous. A checklist in a binder, a notarized letter, a callback to a phone number a bank now knows is associated with an owner. When I stand on the lakeshore now, I think of those practices as the real gavel, the small, repeated acts that, in the long run, shape how we live with one another. They are not dramatic. They rarely make a headline. And yet they are what keeps a town resilient, what steadies a family, and what makes the bitter taste of that 2013 transfer a spur to ongoing repair rather than an occasion for despair. The story continues, through document nights scheduled for next quarter, through clerk trainings planned for the fall, through the quiet conversations I still have with neighbors, and it is in that continuing that I find reason to hope. If I try to put a single date on when the rawest anger began to soften into constructive work, it is not a courtroom day but a sequence of ordinary Tuesdays. The first document night we held in the municipal library in January 2016, the first time someone in the room said aloud the name of a bank and the sort of account it was. The evening a retired notary brought her long leather portfolio and showed a young soldier how to sign across two witnesses. Those Tuesdays followed the trial and the civil judgment of April 19, 2016, which is a day that will always be marked in my family's calendar not because it closed everything but because it forced things into the open. The judgment returned some papers and required corrective filings. It imposed a public accounting that made it possible for clerks and neighbors to see patterns they had previously missed. It did not restore the years I had lost while deployed in 2013 or erase the image of my father collapsing in the judge's chambers, but it did create a legal hinge around which institutional practice could turn. The winter after the trial was busy in practical terms and quiet in emotional terms. My mother and I reorganized the house, moving a binder marked legal from a hall drawer into a bank safe deposit box. I asked, probably too many times, whether a deed was recorded properly, whether beneficiary designations had been changed, whether the power of attorney I had granted before deployment still bore a valid signature. These were small securities against large losses. They were also ways of exerting control in a life that had been dislodged. The binder and the box became emblematic of a larger cultural shift we were trying to seed, converting privacy into redundancy so that no single absence could be leveraged into dispossession. After April 19, 2016, a number of things happened on a timetable that now reads, in hindsight, like a sequence of cause and effect. The town clerk's office, under pressure from a public freshly sensitized to absentee owner predation, piloted a docket annotation practice that autumn. It was modest, a colored flag and a brief line explaining that an owner's capacity or presence had been questioned, But that modesty was its virtue. It increased detectability without burdening routine filings. Lawyers adapted. Title companies added internal flags for combinations of risk factors. Non-local notaries, transfers initiated shortly after a hospital stay, deeds swapped through agents rather than through family members. These were bureaucratic accretions, and they mattered because they made the kind of transfer that had taken my home more expensive in time and scrutiny. The statute that took effect on June 12, 2017, codified one way of doing business that clerks and judges had been experimenting with. It did not invent due process, but it made a threshold verification a compulsory part of certain transfers and provided guidance to banks about the sorts of red flags that ought to prompt a callback. The measure was small in legislative terms but large in its practical effects. An additional phone call or an extra notarization could be the difference between a consummated fraud and a delayed transfer that allowed a family member to notice and intervene. By the time the Regional County Clerk Conference convened in 2018 and included our town's experience on an absentee owner protections panel, there was already evidence that incremental changes propagated outward. County clerks from neighboring jurisdictions took copies of our annotation form and our callback script. Title insurers, who had once balked at anything that might delay a closing, quietly revised underwriting standards that rewarded extra verification. The changes were not the result of a single heroics-minded reform but the accretion of practices. More eyes, more checks, more routine disclosures. In a profession that prizes precedent, the precedent mattered. Some of the consequential stories that followed were small and domestic. In March 2017, an elderly couple who attended a document night left with an updated will and an admonition to change beneficiary designations. In May 2019, a lieutenant stationed abroad wrote from a forward operating base to thank us for an online checklist that had allowed her to reorder some affairs and sleep. By 2019 and into 2020, county clerks were reporting a decline in successful transfers involving absent owners. Banks were reporting fewer suspicious authorizations accepted without follow-up. These were measurable, if partial, victories. The world, however, does not stand still. The events of 2020 altered both the means of life and the means of fraud. In March of that year, when public health measures required the closure of offices and the relocation of many transactions online, remote online notarization and electronic title transfers achieved a speed and ubiquity they had not had before. RON had been circulating for years, but the pandemic made it a default for many who preferred to avoid in-person encounters. The convenience was a blessing for many families. It was a new vector for predators. Within months, clerks and prosecutors everywhere began to notice a new pattern: transfers that emerged from smoothly executed electronic paperwork but whose owners had not been contacted or whose signatures were questionable in ways that the software could not easily reveal. This was a bitter and instructive cycle. Technology solved long-standing frictions: distance, travel, scheduling, and in doing so removed the very frictions that had served as a form of low-grade protection. Predators adapted quickly, using spoofed email addresses, deepened impersonations over video, and the anonymity of third-party mail forwarding. The gains made in 2017 and 2018 were not undone, but they were complicated. Clerks who had flagged physical deeds now had to think about metadata. Banks that had implemented callbacks now had to verify the technique of callbacks themselves. The community's response was again iterative. In late 2020 and throughout 2021, the county clerk convened a working group of clerks, prosecutors, bank compliance officers, veteran service coordinators, and representatives from the state bar. The result was a set of layered recommendations rather than a single fix: mandatory recorded callbacks tied to the phone numbers already on file, a requirement that high-value transfers initiated electronically be confirmed by a second channel, such as an in-person verification or a meeting with an identified attorney when feasible, and training modules for clerks to read electronic signatures for anomalies. The state judiciary issued guidance recommending that judges probe capacity and consent when online exchanges replaced in-court or notarized in-person steps. These measures were not dramatic. They were, again, accretions. They were responses to a new technology that had both widened access and opened a new seam of risk. The public conversation broadened in other ways. Between 2020 and 2022, high schools that had piloted elder law units expanded them. Consumer education classes taught students not just to ask their grandparents where a deed was kept but to understand how the clerk's offices worked and how online scammer tactics operated. The Will Sunday that a parish organized became a model that another parish adopted. It most often involved a short talk followed by volunteers helping people find their papers. These cultural moves, education, ritual, and mutual visibility, had, in my view, the deepest long-term payoff. Laws and clerks can slow predation, habits and relationships can preempt it. The personal angle did not resolve neatly. My father's collapse remained a defining image for me, not only because it was emblematic of humiliation and the theater of a courtroom, but because it exposed the human vulnerabilities that lie at the heart of these cases: aging pride, the poorly articulated wish not to be a burden. After the trial, he retreated in ways that were both infuriating and pitiable. He attended a few document nights at my insistence. At the first he sat in the back and scowled, refusing to let me open the safe deposit box with him present. Later he came, and the scowl thinned. We had to navigate forgiveness and practical oversight simultaneously. The civil judgment of April 19, 2016 compelled a public accounting and some restitution, but it could not prescribe how a daughter and her father would learn to be careful around one another again. There were legal aftershocks too. We learned that civil remedies could be augmented by administrative sanctions when banks or notaries failed to exercise reasonable protocols. We saw a handful of prosecutions in neighboring jurisdictions for fraudulent transfers made during the pandemic, prosecutions that leaned on new training for law enforcement about digital evidence, phone forensic logs, and the metadata of electronic signatures. Those cases were important because they transmitted an explicit message: there were criminal consequences for exploiting absence. But prosecutions came after harm, and harm has a particular impatience. For families and owners, the crucial work is preventive. That preventive work increasingly centered on making redundancy habitual. In 2021, our town's document night added a module on digital hygiene: how to create a durable list of accounts and who has access, how to set up multi-factor authentication properly, which passwords to keep in a sealed envelope in the safe deposit box, as well as a digital password manager known to 2 trusted people. In 2022, the county clerk published a plain language how-to guide for families with links to the State Veteran Service Office. The guide was translated into 2 languages and distributed at senior centers and the county hospital. By 2023, the deputy clerk could point, at a public forum, to measurable declines in certain categories of suspicious transfers, though she would also caution that new methods continued to emerge. The story also widened outward. Veterans organizations took a particular interest because service members, by definition, are often absent. In 2019, a lieutenant's thank you letter had been an encouraging anecdote. By 2022, the veterans of foreign wars and several military family readiness groups had distributed the document night checklist.